And I did just post this link up, but I'll put it so it shows up in the chat transcript for today. But I mentioned this, the Government of Alberta website dealing with these issues is actually very well done. So if you look at the Enduring Power of Attorney page, for example, it shows you that really the government wants you to have this enduring power of attorney. And then if you don't, that's where you have to jump through all these other hoops. And if you want to see what adult guardianship looks like, so this is kind of my point, right? This thing says, if you have an enduring power of attorney, hey, look, you just look at this page and you're done, right? If you don't have an enduring power of attorney, then at some point you're going to end up in the adult guardianship provisions. And that's where we end up back here, decisions for incapable adults. And you can see all that goes into that. And it's a much longer document. Okay. And it goes on and on and on and on. So even just that can be sort of the motivation to get somebody to spend a couple $100 getting their POA done. The other thing I would comment on here, and I'm not a huge fan of legal will kits or whatever the case is. So you can think about, sending your clients to a lawyer is obviously the best thing, but there are good services out there. I know quite a few financial planners who, for their younger clients, will send them to willful.com. It's not a bad alternative. Okay, and it's better than the types of kits you buy at Safeway or Shoppers Drug Mart or whatever the case is. Okay.
Do you have an idea how much those willful, the kits that you're saying cost?
Like if I go to Willful?
Yeah, like, do you know how much the cost is? And I mean, normally it's $350 around PEI here for just a normal.
Yeah, so not much different from that, honestly. Around 100 to, I can't remember exactly. Just a second here. We can pop over and have a look real quick. Did I say willful.com, willful.co, sorry. But anyways, they have at least their base costs laid out. And they might not be in PEI. I don't think they're in every province. So you'd have to check that. But anyways, yeah, around, here you go, $100 to $250, okay? I don't think I agree with minimum of $850 in savings compared to visiting a lawyer, but whatever. All right. Okay. And I don't know if unlimited changes is actually a good thing. I don't want somebody changing their will every week. All right. But there are services, and like I said, I know some folks that use Willful. I think it's fine, not as good as using a full-on lawyer, but Stephen, in the case you're talking about, a 22-year-old, and the prospect of going and sitting in a lawyer's office for 3 hours to get all this done is, intimidating and probably not a great spend. So, do something like this, it's a little cheaper. All right, and it probably gets you sort of 90% of the way to where you have to go, okay? All right. Now, once we have that power of attorney in place, we still have some limitations. This is not going to do everything that we want it to do necessarily. So the law imposes some limitations here. I already mentioned one of them. For our purposes, what is generally the biggest limitation is that an attorney cannot make any change to any beneficial or beneficiary, sorry, I apologize, any testamentary instruments. Okay, now what we definitely know this means is that they cannot alter a will. Okay, that's clear, that's definitely true. They can't write a will for somebody, they can't cancel a will, they can't change the provisions of a will. There is, however, some gray area in some other non-will areas. So for example, if I have somebody who hits age 71, we have to make an RRSP to RIF conversion. That's right. And when you do that, you have to name beneficiaries on your RIF, don't you? So generally speaking, provincial law allows this to happen as long as you don't change the beneficiary from what was on the RIF account. Okay, that's it. Thanks, Bev. Bev's with me here. So that, because technically what I've just shown you, that's a change in a testamentary instrument, okay? Another gray area would be if I have a maturing seg fund contract. Okay, so now if I'm going to rebalance that, or if I'm going to make some change here, even possibly if I have a seg fund contract where the insurer has done a reorganization or restructure, that kind of thing can be problematic. And this is one where you should consult your in-house legal counsel. Okay, because there's not a good answer to that question. Now, changes to insurance policies, real insurance policies, probably not permitted. Okay, again, though, consult in-house legal counsel. Okay. Yeah, changing ownership is probably offside, Paul. I'm not so concerned about that. What I'm thinking of here more so is somebody who's got a term insurance rider on a permanent policy. The term insurance rider is coming up for renewal. Are you with me here? And very expensive to renew those term riders, isn't it? So how do we manage that? That's another good one, Roxanne. Would a policy loan be permitted? That's one that I'm not willing to make a comment on. You'd have to go to your in-house legal team to see what's allowed there. Okay.
Jason, just as a question, and you may be getting to this, but I have a case now where the power of attorney is enacted and they want to transfer all the assets in. But one is a GIF. So there's assigned beneficiaries. They obviously don't have the right to change the beneficiaries, correct? So they'd have to, if I wanted to transfer in a guaranteed income fund or a seg fund, I'd have to keep the same beneficiaries, right?
And even that may not be permitted, Andrew. That's the kind of thing I would run it by in-house legal.
Okay.
Okay, because the RSP to RIF thing is fairly explicit that there's that provision there, but on others, you still could be interpreted as making a change to a beneficiary designation. I wouldn't assume that just because I didn't change the beneficiary, it's still not considered a change to a testamentary instrument.
Okay.
Okay. It's a difficult one. And it's where we do run into a legitimate limitation on POA. Now, as far as the attorney's limitations, the sort of stuff that's more an area of concern for this person. So generally speaking, they cannot pay themselves a fee unless explicitly permitted in the attorney document. Okay, they may be able to reimburse costs. So if they have direct costs, they can typically capture those. That's okay. Okay. And they cannot make what's called a gratuitous gift to themselves. Okay, unless that gift was customary prior to the loss of capacity. So I'll use an example here. Let's say that I have a grandchild or even a child. So the child is appointed as the attorney. Okay, they're on year 3 of a 4-year degree. In years 1 and 2, their parent, the grantor, paid their tuition. So there's a habit or a pattern there. They probably are okay using the grantor's money to pay their year 3 and 4 tuition. Because there's a pattern, there's a habit, whatever it is. Okay, now again, I would run that by the lawyer, but it's probably okay. Okay. Any questions there? Honestly, this is not a great person to name as an attorney. You would be better off naming an attorney who's not sort of regularly getting money from you, because you're really putting this person in a conflicted position.
Jason, can I ask a quick question?
Yeah, go ahead, Paul. Yeah.
You mentioned I have a kind of a situation now, and a guy, he's just become a power of attorney of one of my clients, and he's hinting towards being paid something. And so is there like, what's the word I'm looking for? Is there like a proof, like would he have to show proof of some kind? Like, like you say, where reimbursed costs, let's say, you know what I mean? Like, just to keep it all legal, like, he could say, well, I spent $10,000 on whatever, but you know what I mean? Is there any kind of like proof?
Yeah, so the standard for bookkeeping for that person is pretty high. If they're going to take any costs out, and I don't know what exactly is permitted in Nova Scotia, Paul, but absolutely they want to keep diligent records of every cost they incur, and then any reimbursement. And really, they have to demonstrate that it was required to do that job, right?
So would they be obliged to show me those, or to the client, or?
That's really for anybody who would challenge their handling. So more likely the person who would challenge that would be the beneficiaries named in that client's will would challenge that at some point.
Which probably right now they wouldn't know the situation, right?
Right. So the other scenario where you kind of run into that is, like in Lonnie's scenario, where, you start to see, and I don't know exactly what happened in Lonnie's case, maybe he can speak to it a little bit more, but you start to see that person, like one day they show up with a brand new Tesla, right? I'm sure Teslas are super popular in Cape Breton, but
big time.
You know what I mean? So they show up with that brand new Tesla, or they, the new boat or whatever it is, something like that shows up where you think, oh, like that person didn't have that before. And that's what can trigger those. It's called an accounting. So you're going to request an accounting or a taxation, depends what province you're in. So,
okay.
Or there's another name that I'm losing here. But anyways, there's a legal term for it when somebody else who sort of has a relationship with that grantor steps up and says, I think that this person is being taken advantage of.
Yeah, okay, got it. Yeah, so he can't just tell me that, the client told me for you to give me $3,000 to cover my expenses or whatever, right?
Now, we're going to talk about this a little bit more in a couple of slides, but when you're dealing with somebody who is acting as the attorney, right?
Mm-hmm.
Legally, that person is the client. So
right.
They come to you and say, Paul, I want $3,000 out of that investment account. Unless you have a strong reason to believe that there's an elder abuse scenario or something like that happening, you really have to let that transaction happen.
Okay, and that's kind of where I'm afraid of, because my client, he has dementia, and if I talk to him now, if I say the same thing 10 minutes from now, he won't remember, you know, our conversation or anything like
Yeah,
that, right?
the client at that point, you can't, if the client came to you and said, Paul, I want $3,000 out of my account, you actually could not take that trade request.
Right. Yeah.
You know that person lacks capacity. You can't take instruction from somebody where you know they lack capacity.
Yeah, and this particular guy, not to go on here, but he's been taken advantage of before, so I'm just trying to protect him.
Yeah. Yeah. So the other thing is that you also have an obligation under your rules to FP Canada. Now, you don't have any, technically, you're not UAFP or CFP, so you don't have any obligation to FP Canada, but the FP Canada rules say that you can't do anything that you know would harm a client.
Right.
So if that person comes to you and they, now, I don't know if $3,000 is material, but they want to take a material amount out of the account,
Mm-hmm.
and you can see that that's going to leave your client with a deficiency in 10 or 15 years or whatever, then you can't take that instruction, right? So you're left with this kind of this between this rock and a hard place where, you know, legally the attorney is managing the accounts and you can't deny a trade order from that person, but then at the same time, you can't take an order that would cause material harm to your client.
Okay.
Okay.
All right. Yep.
So,
No, that's good. Yeah. No, you can move on there. Thanks.
okay. I know that's
Thanks.
not a perfect answer, Paul, but there is no perfect answer. Now, I do have some
No.
advice here in a second here.
Okay.
So yeah, and that's it, Lonnie, right? These scenarios, it normally is the case that when the family's paying attention, you're going to see what's happening, right? I'm sure you saw some changes in your sister's spending habits or in the kind of like maybe not the Tesla, but something like that, right?
We had a new car. We hadn't had a new car in about, well, 20 years. So somebody paid for it. Turns out it was my aunt and uncle who actually helped her do all of this. So yeah, get this stuff in place before somebody gets sick. Otherwise, you'll end up dealing with it like me on and on and on. And it cost a fortune to get that POA removed. Once it was in place, you'll have a problem with, nobody will want to talk to you. Nobody will want to give you any information because they can get in trouble just for mentioning any of this stuff. So it took me a year and a half to get this thing removed, probably $6,000 in lawyer fees just to do up the documents, plus all of the time that was spent, plus, you know, all of there's about $30,000 or $40,000 that went missing in a year and a half. And as you saw, I mentioned earlier, she literally used his bank card for every transaction. So that's just foolish in itself. But I mean, I knew every single thing that she did for a year and a half.
Right. And even though you know it's happening, not easy to stop it.
Couldn't stop it. It didn't matter because
Yeah.
she eventually became him.
Yeah, it's difficult. Now, we're starting to see a little bit more ability for police forces to deal with these issues, but still very minimal. Yeah. Okay. Oh, let me see what I can do here, Ryan. Good. Okay. So we already talked about POA for property. We don't have to revisit that. We talked about the institution-specific POA. I do want to mention one thing on the institution-specific POA, and this is something I ran into in particular. So, and this was ridiculously frustrating, honestly, but not a big deal in the end. My wife and I went to our bank together. With me here, I knew we were going to have to renew the mortgage, so we got POA for the bank to deal with the mortgage. Okay, and she has a self-directed TFSA at that bank. You with me here? And so January 1st, I went to deposit, at the time it was $5,000, I think, that's right, into her TFSA, figuring that the POA was going to work. Everybody's with me here? Turns out that the bank needs a different POA from the investment dealer from the bank's investment dealer. So in fact, what we should have done here was to get 4 different POAs, right? One for every institution under that bank's umbrella in order to deal with all affairs. That's good. All right. Okay. You could have that. I think Ryan, you talked before about the Manulife One account, right? So if you had somebody who had an account at Manulife Securities, Ryan, for example, or Maurer, then that wouldn't give them any authority to deal with a Manulife One account, right? Those are 2 separate institutions. Okay. All right. It wasn't that big a deal, Esther. I just had to wait, whatever it was, 4 or 5 months until she was home, and then we did the TFSA deposit, but whatever, it was done. All right. We've already talked a fair bit about POA for healthcare. So remember, this is a separate document. It goes by a bunch of different names. Okay, we can talk about a living will. We can talk about a personal directive, an advanced care directive. I know I'm missing at least one name on here. Okay. So DNR might be part of this, Philip. Yeah. So it's going to include instruction 4, who is going to make decisions. Okay. We give some guidance around under what circumstances not to resuscitate. I found a lot of lawyers today, Philip, have moved away from using DNR. DNR that's do not resuscitate. And the problem with DNR orders is that they're very they're relevant only to today's medical technology. Okay. So if I rewind, for example, 20 years, right? 20 years ago, 25 years ago, I had to think about the time frames here, but ultrasound technology, okay? So, oh man, I don't remember that at all, Ryan. All right. But ultrasounds 25 years ago were science fiction. I think it's about right, maybe 22 years ago. Today, we see ultrasounds all over the place. You can go into a family medicine clinic and get an ultrasound. So when lawyers are aware of that type of thing, they think, well, hang on a second. If I put a DNR in here, it's really going to ruin the sort of opportunity to use what is just standard medical technology, right? We can make the same argument about defibrillators. So, 25 years ago, somebody has a heart attack, yeah, you do CPR, but the defibrillators, now we have them in shopping malls. There's one across the street from my house in our rink. There's all kinds of stuff like that, right? So I find a lot of lawyers have moved away from that kind of thing, Philip, because they say it's just not a reasonable restriction to put in place. Now, that being said, if you had a religious reason, so the blood transfusion thing for Jehovah's Witnesses, for example, that you would typically put in here. Okay, that's good. All right, so it's about who's going to make decisions, and typically what we're going to see is some principles for decision making. Okay, you might include, I see this sometimes where this includes a Glasgow Coma scale. So there's, I don't know if anybody knows this, there's a medical scale called GCS, the Glasgow Coma scale, and it rates somebody on a 15-point scale. So I'm probably a 15 right now. Okay, I am fully conversant, I am awake, I would respond to physical pain, right? All that good stuff. Thanks, Alicia. All right. I did not watch Chicago Med, but yes, those shows often do use that kind of thing. Whereas if I'm in an unresponsive coma with no sign of life and no reasonable prospects for waking up, then I'm a 3 on the Glasgow Coma scale. So, some people will, kind of to your point, Philip, go all the way to including if I'm 4 or less for a period of more than 12 months, then that's when you pull the plug or something like that. Whatever, that's okay. If you want to do it, go ahead. We typically include questions of organ and tissue donation, sort of what's going to happen to the body afterwards, all that stuff. So, and as I mentioned before, it's still up to the healthcare provider to ultimately make these decisions. The idea here is this tool makes it easier for the healthcare provider to make a decision that matches what the person who is no longer able to respond would want. Okay, that's good. So the idea is it just makes it easier for the healthcare provider. All right. Okay, so then we look at adult guardianship. Yeah, it's true, Philip. It's, at least if it's done right, it helps the family, right? The idea here is it relieves the burden on somebody who has to make a difficult decision. You don't feel like you're the one who was responsible for whatever it is, mom's early death. You feel like, you know, you and mom talked about this beforehand. There was an agreed upon set of principles, and you made this decision with a clear conscience. Yeah, that's exactly right, Philip. Okay, now going back to Lonnie's comments earlier, adult guardianship. So I've covered off most of this already. So this is sort of the poor alternative to a POA. And this would be required where there is no power of attorney in place, or for whatever reason it cannot be enacted. So the attorney won't take on the role, or the POA document was not drafted properly. And we have an adult who has lost capacity. Now, this can happen one of two ways. It might be a permanent loss of capacity, or it might be a temporary loss of capacity. Okay. So yeah, it's true. So if it can override a POA where necessary, right? Not an ideal use of it, Lonnie, but as we've heard now, may become the reality, right? So you'll need a legal way to stop her, Lonnie. All right, so if it's a temporary loss of, I figured, yes. All right, if it's a temporary loss of capacity, okay. And I just want to comment here, not to sort of throw salt on Lonnie's wounds, but this has a further problem, right? Lonnie's done a good job of focusing on the financial issues, but I'm going to assume that as a result of this, Christmas is never going to be the same, right? I'm assuming, Lonnie, you will never sit down with your sister and your aunt and uncle again for a Christmas dinner. And to me, and I talked about this before when we talked about estate planning objectives, that should be, for most people, the #1 estate planning objective, okay? If Lonnie's dad had done his planning more in advance and had everything set up well, then Lonnie's sister would have never had this temptation and never been exposed to this, and we'd have an intact family unit still. That's right, isn't it? So I want to use that to rewind back to what I talked about last week when we talked about setting estate objectives. To me, that should be your #1 objective for virtually every person, is that my family is still able to have Christmas dinner together after my estate plan comes into play. Okay. Yeah, the financial side of it is painful, all that good stuff, but I think there's nothing more important. When you talk about this is a terrible, painful example, but yeah, yeah, Lonnie is separated now from his nephews as a result of this and all that, right? So, okay, so it's a normal Christmas dinner, a Christmas dinner that features the normal number of knives, Bev. Okay, so in a temporary loss of capacity, we might seek adult guardianship. It depends how sort of long-term the temporary loss of capacity is. If it's a short stay on a psych ward, then the hospital will actually seek adult guardianship. Okay. And there's a fairly expedited process here for a hospital or a healthcare provider to seek adult guardianship for somebody who is not capable of handling their own affairs. All right. That's all good? And as discussed, there is an onerous set of requirements. It's very expensive to go through this. It's deliberately onerous. This is not an accident. Now, I want to just mention one sort of problematic scenario here. And some of you have clients who are in a position like this or will find themselves in a position like this. Let's say that I have a minor child with a developmental disability. Okay, everybody's with me here? And now this child is going to hit the age of majority. All right. In many of these cases, and I never want to make this assumption, but in many of these cases, this child will not have sufficient capacity to write a will, POA, which is my bigger concern here, and the healthcare directive or whatever we're calling that. That's good? Is everybody with me here? What may be necessary then is when the child hits the age of majority, the parents may want to take early steps to apply for adult guardianship. When the kid hits age of majority. Okay, is everybody with me there? And that might be something you want to talk to your clients who have this kind of situation about, is just how they're going to manage that transition for that child. Because without adult guardianship, when that child hits age 18 or 19, depending what province you're in, they now are their own person legally, and the parents can't put restrictions on their behavior. Okay, so if they want to move out, or if they want to access money that they have in an investment account or whatever it is, they can do all of those things. Okay, that's good. So if the parents want to be able to put those restrictions in place, they want to apply for that adult guardianship order. All right, that's good. This, by the way, this is a dim place to go, but this is where you see a ton of people who end up either homeless or with serious drug addictions, is people with developmental disabilities who hit the age of majority and don't have supports available for them. Okay. Now, we've seen recently, over the last 5 or 6 years, we've seen quite a few provinces add a level of potential supportive decision-making here We normally call this assisted decision-making. This is not a power of attorney. It doesn't have any property or financial results. Yeah, the lawyer, Stephen, they're going to have to go to the lawyer to get that. Now, you don't technically have to use a lawyer to get guardianship, but it's a complicated process. And without a lawyer, you're probably just going to end up floundering. Okay. Okay, so assisted decision-making, it's not a POA, it's not a substitute for POA. That's what I'm talking about, Todd, right? You mean if they're like 25 or 30 and they don't have capacity? Same problem, right? It's exactly the same thing. My comment there really, Todd, is we want to get that done before we end up with a problem, right? So if you can get it done when they're 18 or 19, it's going to be easier and less risk than waiting until they're 25 or 30 or 35 to do it. But the process is the same, whether you're dealing with a 19-year-old or a 30-year-old or a 70-year-old. It's still all the same. The legal process is the same all the way through. Okay. Okay, so assisted decision-making, not a POA, not a POA substitute. The idea here is it's kind of like your power of attorney for healthcare. What it does, it gives your healthcare providers the ability to call the assisted decision maker, which is usually a family member, and say, look, we're having a hard time with a medication. What would you prefer we do? Or can we incur this healthcare expense? Do you have some way to pay for it? It will be those types of questions. So it's questions that are maybe beyond the capacity of the healthcare recipient. Okay, but this person hasn't lost capacity enough to have a power of attorney. Okay, so this is kind of a progressive step in that loss of capacity. Okay, and I'm going to show you another example of this, a financial example of this that some places now have, and not everybody has access to yet. We'll take a look at that in a couple slides here. Okay. Somebody mentioned this already, but everybody on this call, whether you recognize it or not, and whether you like it or not, has some responsibility for assessing your client's capacity. Okay. Now, there is a legal job called a capacity assessor. So we can have a capacity assessor. This is somebody who is trained in various forms of testing mental capacity. Okay, and this is a provincial appointment, usually a nurse or a physician. Okay, that type of role. Yeah, it's not, and this is where, Paul, it's also not necessarily permanent sometimes, right? Sometimes you have somebody who loses capacity and regains capacity. Okay, so we have a bunch of sort of determinations we have to make. So fine, the capacity assessor normally gets involved when a family member, when a concerned family member has called the Office of the Public Trustee or Guardian. Might be a family member or healthcare provider. Has contacted, I'll say, the appropriate provincial office. Okay, that's good. So that's when that person is going to show up. But up until that point, you have the responsibility, and I would suggest any client engagement, to at least have some bare minimum of capacity assessment. So while the client still has capacity, or until they have formally been assessed to have lost capacity, okay, so while the client is in that position, you, the financial advisor, financial planner, whatever role you're filling, has to have some degree of capacity assessment. Okay, now, if you don't, fine, that's your liability, right? Because if you take instructions from somebody who does not have capacity, then that's going to create liability for you. 100%, Shauna. Yeah, and that's why we're going to spend a little time on this. So here is what I would suggest. I'm going to show my best practice for this. Okay. My best practice here is that in every client meeting, now you're already doing this, okay? In every client meeting, you make a point of assessing capacity. Honestly, this shouldn't be anything out of the ordinary for anybody on this call, okay? All it means is you have a normal conversation. Does anybody ever have a client meeting where there's not some small talk or some sort of discussion where we actually are paying attention to how the client responds? That would be a weird client meeting, wouldn't it? Okay, I mean, where the client just went right into, I want to do X, Stephen, here's $100,000 and I just want to do something with it, or where you talked to the client and you weren't sure if they were with it. Yeah, okay, but you knew, right? In talking with that client, you said to yourself, oh, I think that there might be something off here. Is that fair? Okay, that's all that has to happen. It's nothing more than that. Okay, so you assess capacity, which just means you say, does the client understand what I'm saying? Okay, do they respond to what I'm saying? That's it. And what is probably the most important part of this is that you document this. Okay. Yeah, and that's a good example where we can't just think about this for elderly folks. Stephen, I know a lot of times when we have these discussions, we really want to focus on older clients, but that is not always accurate. Okay, so a simple note here. So in your documents, in your client file, you would simply say, client demonstrated appropriate capacity, no change from last year. Okay, that's good. And if you start to show that in all of your client files, as long as it's true, right? If you actually notice a problem, like Stephen is talking about here, then you jot down that problem. You say, client does not respond to certain types of questions, or client doesn't seem capable of understanding certain concepts or something like that, then hey, write that down. Good? Okay, so you might say, or maybe you say, whatever, client was slower to respond than normal. Maybe you say, I have concerns that they're not dealing well with the death of their spouse. Okay, So this is where, Todd, you have to think about how much of an impact this has, okay? So is it enough that you can't take instruction from this person or can't give them guidance, right? And honestly, if I wrote down that response, I'm probably having a conversation with them about the death of their spouse. Is that a fair comment? I'm not making this in secret where it's completely something that I would pretend hasn't happened. That's fair. Okay. But I'm not suggesting, Todd, that I'm not taking instruction from them, right? That's not it at all. Because that to me is not enough reason not to take instruction. Now, that's where I do want to temper the discussions that I have. So if I saw something like this, okay, if this really happened, maybe I say something like, should we meet again in 2 weeks and discuss this when maybe you're in a better frame of mind or something like that. You seem distracted today, client, or you seem like maybe this is a lot to deal with right now. Should we meet again at whatever, 2 weeks, 2 months? I don't know what the right time frame is. And discuss again. And if you're going to do that, okay, if you're going to do that, what I would suggest is you meet on a different day and at a different time of day. This won't always be a solution, but you'll find some people who are very cyclical about this kind of thing. And if you're always meeting them at 4 o'clock in the afternoon, by that time, their mental energy is seriously depleted. We're going to talk about cognitive load in chapter 16. Their cognitive load is heavy and they're not able to deal with their grief or whatever it is. It might be better to meet that person at 9 in the morning or something like that. That's good. Okay. And I think we can think about capacity on something of a sliding scale. Okay, where we have somebody who has a complete loss of capacity way over on the left side here. So we might refer to a complete loss of capacity. And this is really how the law sees it, okay? And way over on the right side, completely in control, but people do sort of move along this scale. All right. I mean, okay, so Mark raises a really strong point here, and this is something that I think we should always be thinking about. As much as the power of attorney is legally your client, it's almost like you're taking on a new client when that power of attorney takes over, isn't it? So I am a big fan of exactly what Mark is talking about here. Meeting, so let's say they weren't, Mark. It's good that they are because you have a relationship, but I'm a big fan of meeting the attorney before everything blows up, before this person loses capacity. And then when the attorney takes over, having a little onboarding process for the attorney, almost like it's a new client. Is that fair? Okay, so we go anywhere from, this complete loss of capacity right up to completely in control. And the stuff you can do along the way is going to vary. So for example, getting married. The capacity test for getting married is very, very low. Okay? You don't actually need much legal capacity in order to get married. It's really the last right we take away from people. Whereas if I look at something like make an investment decision, that's a relatively high capacity test. And it depends on the kind of investment decision. Okay, so this is where, Bev, we have to look at how far along that person is and how much you can do in advance, right? One of the challenges here with certain types of dementia, I know this is the case with Alzheimer's, but I know it happens with other kinds of dementia as well, is that one of the symptoms, one of the behaviors people exhibit when they're experiencing Alzheimer's is that they learn to mask it, right? So we see specific masking behaviors with Alzheimer's. And on top of that, people get angry at the suggestion that they might not have all of their facilities. Okay, so if it's not taken care of in advance, you sometimes do find yourself backed into a corner. Okay. All right, hang on to that thought, Bev. We'll deal with that more in a moment. Okay, are we good here? These are good questions. I'm not trying to ignore the questions that are coming up. We'll work through some of these as we work through the slides here. Okay.
I have another question, Jason.
Yeah.
So what would happen if you had a client who, let's say it's like early onset of Parkinson's or something like that? Can you, and let's say they're a single parent, but they have kids. Can you disclose that to the kids saying, hey, you know, I think there's something going on with your mom and, you know, it should be looked into? Or is that, you're not allowed to do that, right?
Right, so I'm going to show you that. I have a slide for that. There is a way that you're allowed to do that.
Okay.
Okay. But
because that's kind of important. I'm in a situation like that where
yeah,
the daughter told me there's something wrong with her mother. She's not going to talk to her anymore. And now I've noticed things with the mother. So I don't know what to do. So
yeah, so let me work through. I'll show you a couple of things here. It might be too late in that case, Todd, to have an easy fix, but it's something you can think about for future scenarios. Okay, so we'll get to that. We'll talk through some of those issues. So with elders, this is where I would suggest you're most likely to run into a capacity problem. It's where you're most likely to pay attention to it. Okay. But it's not the only place we should be thinking about. That's true, Todd. The Elder Planning Counselor course does some good work around identifying some of those yellow or red flags associated with loss of capacity, right? Okay. So this is where, if you sort of suggest a loss of capacity, I would suggest that it's more likely to be well received, not necessarily by the client, right? As Bev and Todd have indicated, the client might be really angry about that suggestion, okay? But family members might be more responsive to this. And this is where we tend to see more preparation done as well. Okay, so this is where we start thinking about powers of attorney for healthcare and so forth, but that stuff should be done before this, right? Waiting until the last minute is not ideal here. So Stephen mentioned this, and it's a terrible situation, Stephen, but you mentioned this scenario where we had somebody who is not a senior with a loss of capacity. We should not limit a loss of capacity discussion to our seniors clients, okay? So you could have this with a young adult or middle-aged person, and we could have a loss of capacity due to drug abuse. Okay, we could have a loss of capacity due to post-traumatic stress disorder. We could have loss of capacity owing to grief, for example, recent death of a loved one. Could have a traumatic brain injury. It could be just something as innocent as taking the wrong meds or missing your medication. Okay. Well, so that's the problem, Stephen. Yes, the capacity assessor, right? So I talked about the capacity assessor already, but you do, okay? That's true, Roxanne. Yeah, there could be family caregiver responsibilities that just take this person away from being able to engage, okay? So that's the argument here, Stephen, right? Is now you're not qualified to say this person does not have capacity to do anything, but if you're sitting with a client and that client is exhibiting the signs of a lack of capacity, and you decide, despite that, to continue on with the conversation, that's a source of liability for you, okay? So that's where on the last slide I showed, or 2 slides ago, I showed reschedule a meeting for 2 weeks from now, okay? See if things are better in that time. So that's sort of the first step that I would always take, is just to say, okay, client, I think something's not quite right here. Can we meet again in 2 weeks? That's good. Just building in some time can be a very effective tool. And in that time, then you can talk to your in-house legal department. You can talk to senior advisors in your firm. You might, to Todd's comment earlier, be able to talk to family members of that client. We'll talk about that in a few minutes. Okay. But if you take instruction from a client, and this is true both from a financial planning perspective and from an investment management perspective, if you take instruction from a client where you have very little doubt that that person has lost capacity, you will have liability for the results. Is that clear? Are we good there? So why not, Todd?
Well, because it's hard for you to know for sure.
So that's where I didn't say you want to know for sure, right? The argument here is where there's a pretty clear indication. If you're only 10 or 15% sort of suspicious, I would suggest that's not enough. But if you're, say, let's call it 80 or 85% suspicious, that's probably enough where you say, we don't want to do anything.
It'd be like this. What if a client called you and wanted to cash out all their money, or the client called and said, I need you to sell everything and go to money market.
Okay.
And then they're telling you it's the end of the world.
Okay, so first off, would you do that over a phone call?
Well, you have to, don't you?
No, I don't think you do. I mean, so yeah, assuming you have LTA for that client?
Yeah, and then unless you have evidence that the client is, doesn't have capacity. Because that's the situation I faced with a client. And I met with a client. I did exactly like you said. 2 weeks later, I met with a client. Then I met with a client again. And, and it's a husband and wife, and the wife isn't all there, but she's kind of running the show.
So that's where, if you really think that there's, and this is the case, if you took that instruction where you thought that, and I don't know what not all there means. Was she just dealing with some temporary grief, or was there something like that? Or was it really that she had a full-on loss of capacity? Did she not understand the consequences of her decisions?
Well, she understood, I guess, the consequence, but you can see that something isn't right. So.
Right. So I'm assuming you took good notes to the whole thing, right? There's good notes there.
And the husband was there too, and he's fine with everything. So I'm like, okay.
Yeah, I mean, to me, you've got a family member in the room. You've taken reasonable steps to preserve that.
Yeah,
You
and
know it's not in her
he's
best
fine.
interest.
He's 100%. So,
Yeah, that's a hard one to find a reason not to do, right?
but the daughter knows there's something wrong, and the daughter's a client as well. So, anyways, it's tough. Move
Yeah,
on.
it is tough. I
We
don't.
all have problems. So,
Yeah, to me, that's not a problem with an easy fix. But at the same time, you know, the husband is there. He sees the decision being made, and it's
you just got to handle this with kid gloves. That's
yeah,
it.
yeah.
Okay.
Okay. And it's a good question, Mark, right? Is there somebody on your management team or somebody at head office you can talk to about, because I obviously, Todd, I don't know every last detail of the transaction. So, you know, there's questions like, is it a joint account? Is it two separate individual accounts? Some of that would influence this. Is it an insurance product like an AA, or is it an MFDA product? That's going to really influence that. And Lonnie's right here, especially because the daughter is a client, right? So, you know, she's maybe somebody who understands the consequences of those investment decisions, and that could come back to bite you later on too, right? Okay. Now I have this little checklist. This was provided by old FPSC, now FP Canada, and I like it. I think it's a good checklist. I think it's actually worth having something like this. Maybe you just use this one on hand, and not that you would like wave this in front of a client, but have this as a little aide de memoire for your client meetings. Okay, so in the situation you're talking about, Todd, right, sitting down with the wife, I would look for what items on this, call it a checklist, she might be experiencing, okay, or you might be noticing in her. And there's a long list of items here, right? It's, you know, you start off at the top with warning signs. So these are just things that you're likely to observe in the client. Nice. That might lead to some unfortunate outcomes, Stephen. Right. So my wife and I had one of those conversations last night, Stephen, where we were sitting at dinner together, and my wife says, "Tell me what I just told you," right? But I was good. I had it. All right. Okay. So this is back to, I can't remember who made the comment earlier, Bev, was this you? But this is where we get clients who get good at these masking behaviors. Okay, so much so that masking behaviors are actually a symptom of Alzheimer's. Okay, so that's a little bit of a problem. Then what do you know about the client? So what's in the client's past that you know about this person that might show a red flag? So this is, what do you know? Okay. I can't remember, Bev, if it's in the chapter text or not, but you'll have it in today's notes anyways. And I'll leave a clean version in today's notes. Okay. I can't remember if I put it in the textbook or not. Some of these items are in the textbook anyways. So, but yeah, I like this slide here. So clinical observation, this is a little bit trickier, but these would be again, sitting with the client over the course of the meeting, or over the course of a number of meetings. What do you notice? Yeah, and Stephen, this is where you as the financial planner / financial advisor, you're in a seriously advantaged situation for this kind of thing, okay? Long-term clients, and especially clients, you meet with them regularly, a couple times a year or whatever it is, you might be the first person, or you might be an early person to notice these kinds of things. Okay. And I always think of it, it's the opposite. You know, when like a parent with their little child doesn't necessarily notice all the changes that are happening in that child. But if you see that child every month or every 2 months or every 3 months, you're more likely to notice those behavioral change, right? Okay. So these red flags, these are things you notice over the course of a few meetings. Okay. And I would suggest this next step, so assessing capacity in older clients, this shouldn't be limited to older clients. This is what you do already, okay? These are normal financial planning conversations. Probe for the rationale behind decisions. So back to Todd's comment about the client who wants to move to all cash, tell me about that decision. And we're going to talk more about using open-ended questions to facilitate that type of thing in chapter 16, but tell me about that decision. How does this make you feel? These kinds of questions are useful not just for understanding somebody's financial motivations, but for getting to the bottom of a capacity problem. Okay. And then we have our 4 C's of capacity, kind of like the 5 C's of credit. And again, just a basic set of steps, much like any other discussion for dealing with clients who might be in a rough spot. Okay. That's all good. I would suggest that you should have this or something like this as a tool in your toolbox. Okay, I actually already talked about minors lacking capacity. This is where we had talked earlier about getting these folks to into a guardianship position. Okay. Yeah, and Todd, if you had something like this that you were referencing in your notes, do you see how that looks like a system now, right? It looks like you've given this some conscious thought. Okay, so what's the role of the financial planner here? Well, first off, we want to pay attention for this regularly. We don't assume too much. We should be paying attention to this with every client at every age range. It's not a problem that's limited to seniors, okay? And then have a process for when you notice a problem, okay? Now, for these scenarios where a couple of you have already pointed out, where you already have a problem, often it's too late to bring a process in there. I'm thinking about the client where you're dealing with them right now, everything is fine. A year, 2 years, 5 years from now, you have a problem. That's what we really, I think, have to be thinking about, is how do I prevent more of these types of situations? And this is not to pick on people for not having done this. I find this is just something that we haven't paid much attention to, but now we're starting to hear a lot of these kind of stories like what Todd shared, or what has caused Lonnie so much difficulty, or I think Bev, you had one of these stories briefly earlier, right? So it's a matter of thinking about how can I make sure that I have fewer of these problems, like I said, 2, 5, 10 years from now, whatever it is. So have a process. Is it to reschedule the meeting? Maybe before we get there, we have a set of open-ended questions. Okay, do we have some legal processes or some formal processes? We're going to talk on the next page about safe harbor provisions. Okay, know your compliance rules. So what does, if you're whatever you deal with, what does MFDA or IROC tell you have to do? Okay, so what do they sort of back you into a corner on, or where do you have the ability to exercise some discretion, or where are you forced to make a certain kind of decision? Okay, and I think these are good topics to bring up with your compliance teams. And especially if you can paint a particular scenario for them and to have an understanding about how the rules you have in place would influence this one way or another. And of course, as we've heard already, Todd just mentioned it again here, is all the way along, we want to document, document, document. Okay, that's all good. All right, now I want to show something, and I know some of you on the call have access to this and some of you don't. And if you don't, this is something to talk to your compliance team about, okay? And this is what we call our safe harbor provisions. This is a relatively new innovation. Some provinces actually have rules for this. New Brunswick, for example, actually has legislation around this. But in general, we don't necessarily need legislation for what I'm about to show you. So the safe harbor, the idea here is that when you have a new client, any new client, you get them to sign a waiver of confidentiality. And we can take whatever form we want with this, but I'm going to call it a waiver of confidentiality that says, if I, as the financial planner, notice something unusual in a meeting with you about your decision making or about your capacity, then you're giving me permission to call that safe harbor, that family member. Okay. So if I notice something unusual, maybe an elder abuse situation, maybe a weird investment scheme, something like that. So if I notice something unusual, you're giving me permission to call a family member. And we would describe who that family member is. Maybe we'd have one or two people on the list. And you're not going to call that person and go through any detailed conversation. What you would do here is you would call and say, is everything okay with mom? She and I had a weird conversation today. Yeah, it's actually, sorry, it's not mandatory, Grant. It's just that there's legislation in New Brunswick that specifically protects financial advisors who do this. Okay. I agree it's not mandatory, and I'm not trying to make that suggestion. I think it's a great tool. I think the fact that you have this at Investors Group is wonderful, and I think every firm should have this. And if you don't, you should be pressing your compliance team to implement something like this. Is that clear enough? Yeah, and you don't need it, Todd. You don't need it under provincial legislation. It's just that what New Brunswick has done is said, if this happens, then we know that it's okay under legislation. Okay. Yeah, that's about right, Sean. Yeah. Okay. I'm fairly certain, Stephen, that Sun does not yet. And I think it's in your best interest to push for it. Okay. That's good. Just tell them Investors Group has it. Why don't we? Safe harbor is common language you'll hear around it. Sometimes it's called a trusted contact person. Okay. And sometimes called a, well, what else do we have it called? Those are the two most common terms you'll hear, safe harbor or trusted contact person. Okay. Oh, there you go, Sherry. Right, and your compliance department, Sherry, they like this, right? They know that this is a source of really an opportunity for advisors to remove some of their liability from these discussions, right? Is it coming, Sherry? Is that what's happening? Oh, excellent. All right. And you're at cooperators, Sherry, right? Oh, I'm sorry, Sherry. Okay. I don't know why I thought you were at cooperators. All right. At Manulife. Okay. 100% it will, Todd. It's a relatively new thing. The first time that I saw it was in 2017, but now I'm seeing more and more firms use it. I know a lot of independents who do it, and I think it's a really good step. Now, it's not a power of attorney. So this person is not making a decision. Okay. All it is, it's the step you can take to just add to your ability to deal with a client where you're concerned that something might not be right. Okay. All right. Are we all good there? Yeah, I agree with that, Todd. Honestly, I don't know if the size of the account matters in whether we should be doing this or not. I know the size of the account doesn't matter in terms of how much liability you have. Okay. Yes. And I think the more tools you have, the easier it is to deal with those complex scenarios. Okay. There you go, Mark. That's true. Yeah. Okay. Yeah, but your person who has $5 and loses $1 is more materially impacted than your person who has $5 million and loses $1 million, right? Okay. Oh, beautiful. All right. Yeah, 100%. Yeah, and I think, Todd, that's why we have these conversations. I think you have increased liability exposure compared to what you had 10, 15, 20 years ago. You're a lot more likely to find yourself in court talking about these issues today. Okay, let's do one more slide and then we'll break for lunch. And that is around privacy concerns. So whatever the issue is, okay, I cannot have an inappropriate disclosure of information. We all know this, right? Simply not allowed to have this inappropriate disclosure of information. We can't do it. That's right. Okay, so we have to be careful here. So with that trusted contact person or safe harbor, again, it was just to express a concern. Okay, but what about this scenario? So let's say not in a safe harbor situation, but just an ordinary client meeting. And I know some of you have this kind of thing. So let's say I have mom who is elderly and she brings her daughter to the meeting. Is that okay? Now, for the purpose of this discussion, mom has capacity. Okay, I'm sure some of you have seen this. Okay, so that's exactly what I'm looking for here, Paul, this is fine, perfectly okay to do this, but here's what I would suggest you want to do is take 5 minutes, say, look, daughter, right, so that's the problem here, Esther. That's why I want to do this. Take 5 minutes, say, daughter, can you give us 5? I have, and you can blame it on your compliance department. You say, my compliance department won't let me have this conversation with your mom. This is pretty close to the truth anyways, right? They won't let me have this conversation. You can blame me. Say, my financial planning instructor won't let me have this discussion with your mom until she and I have a 5-minute one-on-one. Is that fair? Okay, and that's where you want to take that time, and it might not be 5 minutes, it might be 10 or 15 minutes or whatever the case is. But what am I going to establish here? What can I get done in that 5 minutes? So to your comment, Esther, we can establish any limits or permissions as far as confidentiality goes. Okay, so it's okay to talk about investment accounts, but we won't talk about the will. Okay, so perfect, Bev. Set some boundaries, right? What else should I be thinking about here where the daughter shows up to a meeting with their elderly parent? Okay, so that's fair, Stephen. Even if I did invite her, I still think I should be doing this, right? So yes, how did she end up there? Oh, I see. Did mom invite her, right? That's the question you're asking? Yeah, perfect. Yes, I 100% agreed. Okay, did she ask to come along or did you bring her along? And what's the concern if she brought herself along, Stephen? Right, so we want to look for that elder abuse or any sort of undue influence. Okay, yeah, what's it? Does she have some interest beyond just helping mom out? Perfect. Okay, now, Todd mentioned this earlier. Todd said, well, sometimes you're going to run into these things and you're going to want to say no to the client, and the client is just going to take their business elsewhere. And that happens, doesn't it? Sometimes we sort of come down with a hard line. Okay, and I would say it's unfortunate, but I don't want to be the advisor who's on the hook when we start to see this happening. Okay. Does that make sense? Instead, I say, fine, client, I'm not willing to help you sort of sink your own boat here. If you want to do this, you're going to have to go find another advisor who will help you out. Okay. Yeah, it's true, Nicole, right? And that job protection, it's a little bit of a double-edged sword because you can't just be firing clients left and right, but at the same time, you don't want to keep clients who are going to land you in court. Okay. Yeah, I agree with that, Mark. I think those are not going to be good financial planning clients. The person who thinks you have no value to add to this discussion is probably going to cause you problems elsewhere anyways. Is that fair? Oh, that's amazing, Grant, right? Those are terrible scenarios. And, you know, what can you do there? But the other comment I have around the situation Grant presents is sometimes when the advisor fires the client or when the advisor even suggests such a thing, that can help the client to wake up too. The client might look at that and say, wow, it's more important that this person doesn't deal with me, that is, they're willing to give up the revenue that I generate for them, maybe that's an indicator of just how important the issue is. Okay. Okay. My favorite, Mark, is when people come from something they learned on Reddit. That's the best. Okay. Nice, Stephen. Yeah. All right. And there is a cultural thing here, Stephen. I didn't want to ignore your comment earlier, but there is a cultural thing, right? Where if you have sort of that perspective of the family where everybody to some extent is comfortable talking about one another's financial affairs, it's a big difference than if the first time this shows up is when mom is 75. Okay. Yeah, I know, Mark. All right. If I want to be angry about CMHC, Mark, that's where I go, all right? Okay. Perfect. Okay, yeah, that's true. All right, any questions there? I hope that's helpful. I hope that I have given you some tools. I think that this capacity discussion is a hugely important topic today. I think it's a place where there's a ton of liability for advisors and opportunity for advisors to do a ton of good for their clients if it's handled well. Having a system or a process in place, I think, makes a world of difference here. We have some tools that we didn't have a few years ago. Okay. Yeah, I have no doubt about that, Todd, right? I think that's what brings people to a class like this, okay? If you didn't want to get better, you wouldn't spend 20 days, I think right now, 19 days, whatever it is in class with me, right? Okay. Yeah, and with each other, honestly. Jeez. Okay. I do think, Stephen, that that's a value in that trusted contact person form. Okay. When you're, yeah, when you have that kind of tool available, I do think it gets people to wake up a little bit and realize that the conversations you're going to have with them are about more than investment returns and budgeting. Okay. Yeah, that would be nice, Mark. I agree with that. Rather than have that person show up unexpectedly. Okay. All right, I have one more slide related to powers of attorney and related issues. We'll deal with that after the break. Other than that, it's a good time for our lunch break right now. I have 52 minutes past. Let's take a 45-minute break, and we'll resume then at 37 past. Email lunch, Paul. That's right. All right, we'll see you back at 37 minutes past. Thanks.